All right, man, we are live.
Hey, everyone. Thank you for Jayson and our special guest, Brett, joining us today. So, got spoiled 2 days in a row. Just brought you guys all together to provide the different um, directions or different viewpoints of some of the things dealing with a couple of our amendments and freedom of the press, freedom of speech, but also combined with public or duty to a public trial, speedy trial, and with the lawyer. So first, I was kind of interesting when I was looking at the history of true crime. It looks like some of the issues that we deal with in terms of what we see in terms of social media or whatever, or the press, goes back centuries. So it seems like we kind of deal with the same problems that we did then in the past. And Jayson and I were kind of talking about it. First, start off was, as I understand, was that back in right after the printing press came out, was that what they would do? They did two forms. They would print pamphlets and they would send it out to the upper and middle class people. So, and then it sounded like even people back then were very much interested in the same thing that we are today. And even they wanted to look at these gruesome crimes. They wanted to hear about the stabbings or the fights and broke out. They wanted to hear about all these things. And the other form that they used was the ballads. So they would sing songs and create the songs for them. So it seems like the people a couple hundred years ago kind of felt the same way we do, where we really want to know the details and know what's going on. So any comments, I guess, the question about going that far back with the true crime?
Well, I think, this is something we talk about sometimes when we talk about ethics and true crime and people who wonder if true crime can be ethical and should we even do true crime. And to a certain extent, I feel like we should try and be ethical about true crime. But this notion, it's as part of us as any part of human nature, going back to the cavemen. And I wouldn't be surprised if you could find cave paintings of true crime. It's just, it's an innate thing about humans. They want to know about these kind of crimes. They want to know the details, and like you said, the gory details. They're fascinated by mysteries. I mean, that's just who we are. And like you said, as long as there's been the press, literally the printing press, you've had this tension between how you're going to describe crime to the masses and how you're going to allow the masses to be part of finding justice and protecting the rights of the accused.
Yep. And if you look at journalism, even pre-printing press, oral stories, and to your point, I don't know about caveman drawings or hieroglyphics in temples, but we, Brett's point about mysteries, we seek to understand the world around us, and we use narrative to understand the world around us. And just like we want to hear love stories and we want to hear about travel, we want to hear about things that we haven't experienced so we can better understand the world, feel safer, plot our course. I think it's the same thing with true crime or any criminal justice reporting. It's really about understanding the world around us. And I do think, and to your point, Brad, about ethics and true crime, I think a lot of people take the position that it shouldn't be entertainment. And I think it is entertainment. Anytime that we're taking our time outside of our sort of work or kids and things like that, we're doing it because we get some kind of fulfillment out of it. But it's also, there's an opportunity for it to be informative and to educate people and make people smarter. So I think that that's been true, Mike, to your point, since the beginning of time. And we've had different periods, right, where it becomes more sensationalistic, like the Joseph Pulitzer, Hearst, William Randolph Hearst, yellow journalism periods. But during those same times, we've always had responsible creators. And I don't think it being entertainment or it being journalism or being advocacy really solves the problem. I think it's just really about being responsible.
Correct. So let's talk about the next kind of phase that I looked when I went in the history, and that dealt with that yellow journalism with the William Randolph Hearst. I guess in the late 1800s, early 1900s. I mean, these were the guys that went out and created a war. I mean, they went out and created a war.
Remember I mean,
yeah. And it seemed like, I don't know specific cases from that. I don't remember, but there was, but it seemed like those two really built it up too in their reporting in those newspapers back in the 1900s. So
Yeah,
I don't know if you know of anything about them from. Did you ever talk about them in terms of true crime? What they did?
Yeah. Oh, well, certainly in journalism school, we talked about them, right? We have the Pulitzer Prizes right now that are the most prestigious prize in journalism, and they're named after Joseph Pulitzer, who ran the New York World, I think. And, Pulitzer, it's a bit of the Pulitzer Prizes and putting the money toward that is a bit of a whitewashing of his legacy of sort of being a huge yellow journalism. And what it really was, there was a battle in New York between Joseph Pulitzer and William Randolph Hearst. And essentially that battle peaked like 1890s. I think it was like the mid 1890s. And it was all about sort of sensationalism with very little substance, right? You take the most salacious rumor, even if it isn't necessarily true, and you run with that. And Brett was making the reference to Remember the Maine. That's about the USS Maine, which sunk. Was it Cuba?
Yeah, it was in Havana Harbor. Yeah.
It was in Havana Harbor, and it sunk. And the way that publishers responded to it, or at least the yellow journalists, was that it was obviously an attack. And, it could have just as easily been an accident. It could have been an assortment of different things. But that attack then, of course, led to a war. And I think that's like the cautionary lesson that we learn in journalism, which is the U.S. government gives us all these freedoms, the ability to do things that very few citizens are allowed to do. And well, anyone can be a journalist, but they do really give us a lot of freedoms. But with that, I think comes a responsibility. And not to say that all true crime creators are journalists, but a journalist is really just a person who collects information and shares it with people. And I think we all really do that. But I think what yellow journalism tells us is that it is really important for us to be responsible. I don't know, Brett, as somebody who's coming at it from both a prosecutor and lawyer perspective, I imagine there's probably a real impact on the day-to-day job when we are responsible or not.
Yeah, and I think it goes back to that old saying, if you those who don't know history are condemned to repeat it. And we think sometimes that everything that we're dealing with now is new and nobody ever had to deal with it before. But the sensationalism you see on YouTube used to be in the newspapers, right? And it goes back, like we were saying, as far as you can go. And some seminal moments are colored by it. If you think about the Boston Massacre was heavily covered in colonial newspapers, and it was obviously tilted to be anti-British. And the real story of the Boston Massacre is a little less black and white. And in fact, I think it was Sam Adams who ended up defending the soldiers in that case and actually got them acquitted because he believed everybody deserves a fair trial. So from the very beginning of American history, you have this tension between the news, how you cover crime, people's consumption of crime, how it colors their view of the world. And you see that right up until today. And I know, we're going to talk about the Sixth Amendment and the First Amendment, and where those really clashed was, one of the 30 or so trials of the century in the 20th century. It was like there was a trial of the century every couple of years.
I was going to cover. Yeah, I was going to cover one of those.
I don't want to jump on it, but that was sort of, that tension got all the way to the Supreme Court.
Yep. And there's this, I love this, and this is another journalism school thing, but I love this quote, or these quotes from Thomas Jefferson. He wrote in his letters, and Thomas Jefferson, these are optimistic things he said before first becoming president. His views were probably a little more jaded afterwards, but he said, one of his quotes that we learn is that the basis of our government is the opinion of the people, and the very first object should be to keep that right. And if you were to let me to decide whether there should be a government without newspapers or newspapers without government, I shouldn't hesitate a moment to prefer the latter. And another one that he had was, our liberty depends on the freedom of the press that cannot be limited without being lost. So I think the underlying concept, when you're thinking about, from the perspective of journalists, our role and our responsibility is to create an environment where people have information so we can ensure that the country is governed by the will of the people. And for me, there's an inherent, when you start to get into the, it's sort of a sacred trust, right? We need to treat our sources with respect. We need to maintain our independence as journalists. We need to have integrity, right? And we need to inform the public. And we have to insist on transparency and accountability with government. And you can see how all those things, right? Informing the public and ensuring transparency and accountability, they really support justice, the rights of defendants, but you can also see where they create conflicts, right? Investigators often want to hold back evidence to make sure, that they have the right person for a confession, or prosecutors, judges, defense attorneys don't want to, prejudice juries. So you get this real conflict, I think, between, the idea of how do we have fair trials, fair, effective investigations, but also hold government, the system, accountable, because I'd hate to see a system where we had trials, we couldn't cover investigations, trials were held in secret, appeals were done in secret. It just wouldn't work. So how do we find that right balance?
Yeah, and I guess, sorry, that was when I wanted to move forward with the history and then get to that, because one of the things I did want to talk about, and probably a little bit, was just that I see the journalists and the press as being really a check of the checks and balances that we have in our government. I mean, yeah, we have the legislature and the judicial branch, but what is there anything that has a chance to check those things? And I think that's the responsibility of the press. And that's one of the, by the reporting of what's going on in the courts or doing stories on the cops. To me, that kind of seems like as one of those last checks that the people have more involvement. I think one of the differences now is that because everybody can be a journalist, it does give everybody some type of a chance to be as a check. Do you guys agree with that, Brett?
Well, yeah. I think there's a reason that one of the most powerful, important positions in any sort of authoritarian government is the role of censor. The czar's censor in Russia. There's a reason you need that if you're going to have an authoritarian government, because the power of the masses will always be greater than whatever government is in place. It's very difficult, no matter how powerful a government is, to hold down people who know the truth and are inspired to do something about it. So I think, and I've always thought this, that things like, I love the Constitution. I've taken an oath to defend the Constitution 5 or 6 times at this point. It's the bedrock of everything we do. But at the end of the day, it's just a piece of paper. It's just words written on a piece of paper. And the American Constitution is recreated in countries such as North Korea and China. In North Korea, the freedom of the press is absolute. That's what it says on their document, but it actually doesn't mean anything. But in the United States, it's not just that we have the First Amendment. It's that there is this institution and this foundation that we all sort of have come together and agreed upon, which is that the press is necessary and free press is necessary to uphold our freedoms. And I think people sometimes lose sight of that. You see, and I get it. I get mad at the press. Everybody gets mad at the press, right? Everybody gets mad at the YouTubers doing terrible things on various cases we love. But I think it's always important to remember the cost if you didn't have that. Okay, fine. You wouldn't have some YouTubers who annoy you, but the cost would be so much greater than the benefit that you would receive because of it.
Okay. Well, I also wanted to, I guess you brought it up earlier. I guess one of the interesting cases that I looked into that was considered, I think, more of the crime of the century, and I don't think trial, but had a big influence on the media in the courts, was the Charles Lindbergh baby kidnapping. So for people that don't know the details, I don't have to get too much into it, but the guy that flew in the Spirit of St. Louis, he had a baby, and it was he was at home. I guess the family was at home, and somebody came in, put a ladder up to the second window, came in and kidnapped the baby, and then took the baby and ended up murdering the baby. But at the same time, what they did, they also, I got some feedback. I'm not sure from where. So he put out a ransom note, which Charles Lindbergh paid, and then what ended up happening was that they actually marked the bills, so they knew. So they marked the bills, and then what happened was when the guy tried to pay it, he went to the gas station, paid with some of the marked bills. The person at the gas station way back then called the cops. They followed him and chased him, and he fled. And then later they found some of the wood from his workshop was actually they thought was used in the ladder. So that's kind of the things. But the reason that the media played such an important role was actually, I think this was the first time telegraphs, I think, or the teletype, one of those two, was involved in the courtroom. So the problem that they had in the courtroom was that they had all these teletypers typing out as it was going on and distracting the court. So I've heard and understand that this led to a lot of for a while, why we never had phones and cameras in the courtroom was because this was so distracting. I guess it also talks to you about another things that with the journalism of it is that I guess it was the first one that was majorly covered in the press, and the press were actually like the jurors would have to walk by like all the press stations and the press people like as they're walking to court. So I mean, the press would be interviewing the jury as they were going on about what's happening. And I also understand like when they were at their hotel that they weren't like there wasn't enough sequestering. So as I understand that the journalism really got involved in this case. Well, and I think Charles Lindbergh said that even though I don't know if he said it was the right decision or not, I think he said that this was the first trial really tried in the media and not in a courtroom.
Well, so, Mike, I think there's something really instructive about this particular case because you're seeing something very similar happen. And I know Brett and Alice have talked about this. I think you had mentioned on your podcast, Brett, that you had gone to an elementary school and talked to them, or no, not elementary school, excuse me, law enforcement, and talked to them about the danger of vacuums existing. And I think the Delphi case is a perfect example of that. But I think part of what created the problem for investigators in the Delphi case was, 2017, when the girls, Abby Williams and Liberty Germain, are murdered, we did not have the prevalence of social media that we have today, YouTube channels, all that stuff really grew during that time period. So everyone was caught sort of flat-footed as media was changing. And that's exactly what happened in the Lindbergh case, because that was the first major case where the three pillars of the modern media popped up: radio, journalism, and what they called newsreels then, which later became things like television and digital media today. So it was a press atmosphere where the story reached a much broader part of America, and the court systems, the government systems for managing the press really had to shift. Television or newsreels were an emerging form of media at the time. And I think that part of the problems and that really sort of were created there, really center around how do we view this new media? Is it really free press? And I think people ask those same questions about YouTube channels today. And do they really have First Amendment rights? And so there can often be, I think, anything as delicate as national security or the criminal justice system, when there's something new, it can be really hard to adapt to it. But you can see in the Lindbergh case, and you can also see in the Delphi case today, the costs of not being able to adapt fast enough. And I'm not sure what the solution to that is, but I think they can be really, 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 really instructive, if that makes sense. Like the Lindbergh Baby was the first home movie to ever be sort of on the newsreels, and the coverage was the first time it happened. I think at the time there were like more than a dozen daily newspapers just in New York City covering it. And it takes time to adapt, and we're seeing that same challenge today.
Yeah, and just to echo that, the judicial system, to its credit, is built on hundreds of years of experience, but it takes hundreds of years for it to develop and change, and the speed at which media is developing is just astronomical at this point. I mean, we see that, who knows what'll be going on in 5 years. And like you said, in 2017 doesn't seem that long ago, but it's a lifetime in the media, and the courts are terrible at adapting to developing media. They're probably about figured out blogs by now, how to handle blogs, and that's about it. Twitter, wow, what are we going to do with Twitter? And then you start thinking about YouTube and TikTok and all of it. And the thing is, you have some people who I think are naive. Like, I want it's cameras in the courtroom, right? We still haven't figured out cameras in the courtroom, and cameras have been around for 100 years, right? And people are like, well, if anybody could go to the courtroom, what's the difference? There's a huge difference between broadcasting to millions of people who then are going to turn around and have their YouTube channels and their TikToks and everything else. And the pressure, the immense pressure that puts on jurors. And we all recognize the pressure jurors are under. And if you just think back to a really good example, just the pressure, the community pressure in like 1890 in a courtroom in a small town in the South when a black man's accused of killing a white woman, the pressure on that jury to convict is immense, right? I mean, they can't go home if they don't. And you take that, and now it's amplified 1,000 times. And that is going to have an impact on your judicial system, and it's going to have an impact on the sanctity of your verdicts. And now, for better or worse, I mean, maybe these forces fight against each other. You don't just have the pressure to convict, which is what you had in the Lindbergh case, right? In the Lindbergh case, there was this fervor, international fervor. I mean, that might have been the first internationally covered case to convict this man, who I do think was guilty, but to convict this man of murdering this hero, this world hero, most famous man in the world. I mean, it would be like if Lionel Messi's child was kidnapped or something. It's hard to even imagine a situation like that happening today, to convict this man. And they really, the jury had no choice. They had to convict him, right? So that's what you had then. Now you're seeing sort of the opposite side of that. You also see a very powerful block of people who, for whatever reason, never think it's whoever the police arrested. Whether it's the Karen Reed case, the Delphi case, or some people in the Brian Koberger case, there's just this strong block of people who believe there's some sort of conspiracy. And now they are also pushing and trying to influence the jury, and trying in some cases to influence witnesses even. And that's a huge problem, because that's not how we're supposed to decide whether someone's innocent or guilty.
Yeah, and one thing I wanted to bring up in the trial that the ones that I've been following today is, like, you always worry about the witnesses getting their testimony, learning about the testimony if they're supposed to be sequestered. It happened on Friday or Thursday, I think, where they were worried that the juror or the people that were supposed to testify next were listening to the YouTube channels, like in the hallway while waiting the test. These guys know what the questions are going to be. They're going to know what my tactics are going to be and what I'm going to ask. So can you please tell them not to watch YouTube in the courtroom? I think I'm surprised that the courtroom doesn't block, like, offer Wi-Fi, but then block certain sites for people. I think that would be a technology change that maybe they could think of doing. I don't know. Maybe I'm wrong on that, but it's just.
Mike, I don't know that the answer is really technological. I remember watching, actually, on, I think it was Court TV or Law and Crime, the Roden murders in Ohio, where the family was slaughtered by the boyfriend or the ex-boyfriend of one of the girls' family. And I was really amazed by the witness instructions that the judge was giving. He was like, do not read newspapers, do not read X, Y, or Z. And he was like, Twitter, Facebook, blah, blah, blah. And his list just went on to hammer home the point, right? That there is a real cost to you exposing yourself to any of those things. And I think we just have to adapt to some extent to our communications, because ultimately the people who are going to want to try and cheat the system are going to find a way to cheat the system, right? Whether it's like looking at it on YouTube or asking somebody who's in the courtroom who will whisper it back to them. But I think it's about being really clear, because sometimes I think people trip across it. Like, they don't realize the algorithm is going to send them X, Y, or Z that they're working on, or a friend sending a message. So really equipping people, witnesses, jurors, other people, with tools and information about what to stay away from, I think is really going to be effective, right? Because if I'm the guy who wants to know what the other witnesses are saying and you block the Wi-Fi, I'm going to walk over to the cafe across the street and get it anyway. So,
Well, yeah, we heard one case that we won't name where the one person was like it seemed like they were walking. They would come in the courtroom for like a few minutes and then walk across to the 7-Eleven across the street and tweet about what was happening and spread it out. So I guess it's not just technology, but how do you prevent like the people doing are trying to do the testimony from like talking, or even can you even do that?
Brett draws and quarters them.
Yeah, I think honestly, communication has reached a point where I don't know that it is possible to stop them with technology, like Jayson was saying. I am a hopeless optimist. And so I think really the only thing you can hope to do is impress upon people, kind of like Jayson was saying, and it has to be the right people. I mean, your jurors are the most important people, right? Personal responsibility is something that we just, when it comes to these kind of things, we have to emphasize and we have to make a value in our society, in our legal community, because I don't think we can stop it. We can't, centrally plan how to stop people from being able to view things they shouldn't view like we used to be able to. In the old days, you could sequester a jury. Now, think of the OJ case. I mean, do we really think, even back then, that those sequestered jurors weren't getting information from the outside? Of course they were. But at least you could try. You could try and lock them up, basically make them prisoners too in a hotel room under guard where they can't leave and they can't watch anything and they can't read anything. You could try and do that. Sometimes it was successful, sometimes it wasn't. Now I think that's just impossible. And so I think what has to matter to people, and I think what does matter to a lot of jurors, is I think most jurors really want to get it right and they really want to decide things based on the evidence. And I think most people understand that if you expose yourself to stuff you shouldn't see, it's impossible to put it out of your mind. You can't watch the coverage and it not affect you. So I think that it has to be, and I've seen judges do this and do a really good job of reminding jurors that, their service, as a lot of judges like to say, there's the United States military and then there's jury service. And a lot of people can't be in the military. I'll never be in the military, but you can serve on a jury. And when you're serving on a jury, you're upholding one of the most basic things. I mean, why do we have government, right? You go back to your political science class. Why do governments exist? They might exist for a lot of different reasons, but the core reason is to ensure that people who are wronged can right that wrong without resulting to, vendetta and destroying a society, and ensuring that the people who are accused of the wrong can get justice. And both things are important. Sometimes we focus so much on the rights of the accused, we forget about the whole justice for the victims thing. But both those things are critically important. And I think it is possible to impress upon people, in particular jurors, so that they will not pay attention to the things on the outside. And I think it's also important for all of us as consumers to remember that as well. And that goes back to something we talked about at the very beginning. True crime is entertainment. It is entertainment. I am entertained by true crime. But to always remember that in every story, every single true crime story we do, there are real human beings behind it. And you have to remember that, and you have to honor that, no matter what you may think of the case, or no matter what you think of the story, no matter how much you enjoy it. You always have to remember the real people behind it.
Yep. And I think that's all the more reason to be careful with all of it. Brett, I like to tell every defense attorney I know that as they go on about the Sixth Amendment and, the other amendments, hey, justice is the 17th word in the Constitution. The reason why we have the Fifth and the reason why we have the Sixth and the reason why we have all these defendant rights is the natural need and desire and necessity, right? So we don't result in vendettas, the necessity for justice. And all of those things are really just meant to be counterweights, but preserving justice, doing it with humanity. I see so much in the true crime space. The things that tend to bother me tend to be unnecessary harm to people, unnecessary harm to victims' families. We have the whole battle right now, a battle going on over the Delphi case of the Justice for Abby and Libby hashtag. And I was in a back and forth on Twitter with somebody about it today, where they had said, well, due process is also important. And my reply to them was, what about not using a hashtag that was created by the families for their girls prevents the defendant in that case from having due process? And there's nothing. So I think being able to, as a creator, as a true crime consumer, as somebody comments on social media, any member of the press, to really think ethically, right? Like, how can I do it, whether it's entertainment or information, or whether it's holding government accountable? How do I do this in a way that minimizes unnecessary harm?
Yeah, and I think we also maybe should practice a little bit of humility. I mean, I would like to think that everything that I say is so important that the entirety of the Constitution weighs on every one of my words. But the reality of the matter is, me using a hashtag on Twitter is probably not the thing that's going to ensure that due process survives in this country. So therefore, if I can choose not to use that hashtag and not harm a family who's lost two girls, I'm going to choose not to do that. And I can still make all my arguments about justice and everything else. And I think you're right. First do no harm is a really good principle, no matter what profession you're in and no matter what you're doing in your life.
Okay, thank you. I guess, and now I'd like, maybe switch back, and I had a question, switch back to the original topic of the 4 points of the two amendments and where they clash, right? I guess, so we have the freedom of speech, freedom of press, but we also have the right to a public trial and an impartial jury. So the argument, and always in the past, has been that the reason why we don't want to be tried in the media, so like they want to limit the exposure to it. But I'm wondering, like, my argument today is, has that maybe been flipped with the social comment or the social outlets that we have? So maybe sometimes the defense will actually want to be will the defense ever want it to be tried in the media now? Because I mean, I'll try and finish, because I don't know if it's a good point. Because normally, like in the past, the media has never been very critical. I mean, maybe you'd see it too differently, but it seems like by the time somebody gets to the courtroom or a trial, for the media is pretty much on the side of the state that this guy's guilty. That's where it seems and they haven't been as critical today. But now, if you have these, you have Mata and others that are talking about what's wrong with the state. Is that something that might help the defense now or in the future? Or am I barking up the wrong tree?
No, I just think it's not new, right? Like, the state has an enormous amount of power, right? They've got very large budgets. They have the fact that they're ahead of the defense and the investigation on their side. They may have more resources. That's not, always the case, because the OJ case gives you an example of where that's not necessarily true, and there are probably some others. So defense attorneys often have to leverage what they can, right? And I think sometimes the media can be very helpful for a number of different things, right? Holding government accountable is a part of it, but sometimes trying their case in the public. And I'm sure prosecutors do it too, but I will say, from my conversations with defense attorneys, they will often say to me that they have to leverage what they can, right, to kind of balance things out. I don't think that's new. I think the new thing is that we have, and I really do think this is, it might be being naive here, a kind of post-serial podcast thing, where there is a large contingent of people who just want to believe that every person is innocent, like on the slightest bit of whatever piece of information may be weak or may not be what we thought it was. And so I think, I think that some defense attorneys may want to leverage that. They've done it before, but leverage social media now to work toward what they would say is leveling the playing field. Now, the journalist in me will tell you, you mentioned impartial jury, and I would say the press protects all your Sixth Amendment rights. The one about unnecessary delay, your right to a lawyer, your impartial jury, to know your accusers, know the evidence against you. It's the press that holds the system accountable for all those things. And that conflict may come in over an impartial jury or tainting the jury pool in either direction, right? For the prosecution or for the defense. But it goes back to that point I was making before. Do you want the other world where things are held in secret? Probably not. So how do we find that responsible balance where the press plays a role in, the Times? Is it the Times phrase or journalism phrase? Our job is to comfort the afflicted and afflict the comfortable, but it's also to hold government to account, right? So how do we do that, right? And how do we do that in a way that doesn't harm a defendant's rights, or frankly, not just the defendant's rights, but tip the scales of justice in any direction? Because those of us who are in the press, who are responsible, we're focused on the truth. And so whichever way that truth lands, we're focused on the truth.
But I guess, trying to understand in the past, how good, were the journalists going into the depth of the case that we see now? We get devoted. We have some of these cases have 15 episodes on it. And the one of them it was after the case, but we go into a lot more depth than I saw. Normally all you would see on the case is like your 5 second or 30 seconds on your local news station that says, well, this person's been arrested and he's going to trial next week. So there's not like,
I get what you're saying, Mike, but just we're not blind. But a couple thoughts for you there. We can publish faster now. We can publish so much more, right? You see all those data centers out there. Newspapers used to be limited to what they could print on a printing press. So a lot more of information is out there, but what the research and studies show you, you may think that in a lot of places they can't get an impartial jury, but guess what? Most people are not doing what we're doing and paying attention to every detail. So what might be out there, but I don't think it's as big a challenge as some people make it out to be. I can't think of a lot of examples where they've just sort of given up on finding a jury because nobody could set aside what they know.
Yeah, I guess it was kind of interesting because I talked to my defense attorney friend, and she had the point that the average jury level was like a ninth grade level. So it was sometimes hard for both. She'd say that it was hard for both lawyers to kind of not have to be able to explain it. So maybe. And I thought, Brett, and maybe one time, you want jurors that are out there to make these decisions. Somebody that, the problem is that you want somebody that follows the news and that's somebody that's kind of educated. So you don't want them to know what's going on and have a higher level and be involved. So it's kind of a catch-22 of what exactly you want.
I think the prosecutor in the Casey Anthony case said their problem was by the time they got to trial, the only people left who had never heard of the Casey Anthony case are people you'd never actually wanted a jury. Because it was like, what kind of life are you living that somehow you live in Florida, an hour away from where this happened, you have no idea about this case? So that was a problem for them. And look, I think anything worth having is going to have a conflict. There's always going to be a tension between the things that we value the most because they often conflict, and the First Amendment and Sixth Amendment in some ways do. You think back to the Sam Shepard case, which we've talked about on our podcast, which is the case that generated the Supreme Court opinion that really led to gag orders because the initial conviction was overturned because it was so tainted by the press coverage that the Supreme Court said, look, that violated his Sixth Amendment rights, and you've got to figure out a way to deal with that. And gag orders have been sort of a way to do that. But I think, the thing about press coverage, you want your case, you don't want it tried by the press, but you certainly want it tried in the press. As Jayson was saying, you want people to know what's going on. You don't want secrecy. Secrecy is always bad. You never know whose secrecy is going to benefit. You don't know, which side is going to be the side with the thumb on the scale when nobody's watching, but usually somebody is. So you don't want that. And I think you've seen cases. I don't really like, one thing that always bothers me and concerns me is when public pressure leads to someone being indicted. But you've seen cases where I think public scrutiny has led to indictments. I think about the Ahmaud Arbery case in Georgia. Mm-hmm. If that video had not become public, they would never have been charged. I think the decision had already been made not to charge them, but because of the press and the ability to get that out, the George Floyd case, I think if you didn't have the video, if you didn't see it, a lot of police brutality cases, frankly, if you did not have press coverage, those are things that just would never, nothing would ever come of it. And on the other side, you talk about tainting juries. Prosecutors, we do have a lot of power. Typically, our access to the press ends at the arrest. Defense attorneys always like to talk about that initial press conference where you go out and talk about, hey, you got the guy, and now they got to play catch up. But the fact of the matter is, they can pretty much, unless there's a gag order, play catch up right up till trial. Whereas the prosecutor at that point is ethically obligated to essentially stop talking about it. And then the defense attorneys sort of get their opportunity. I think about the Alec Baldwin case right now. You see a lot more from the defense side in the press than you do from the prosecution, because obviously the prosecution, they say everything in filings, and they've started writing these very sort of vitriolic filings, the prosecution has, I think, in an effort to sort of get the press to pick up on their side of the story, because they're also trying to get there. So look, it's not ideal, and it's a balance, but I think this goes back once again to personal responsibility and deciding what you're going to consume and what you're going to reward and what kind of coverage you're going to reward with your time, which equals money for whoever's covering it.
Yeah. And one of the things, Mike, that I've read recently is a little bit of research that suggests we're getting gag orders more and more. And I think some of that has to do with not knowing how to deal with these new forms of media and how they're impacting things. So, 10 years after the Shepard case, there was this case, I think it was Nebraska Press versus someone, but I call it Nebraska. But in that case, the Supreme Court said that on gag orders, they were to be presumed unconstitutional unless they were the least restrictive means to protect the defendant's rights. And one of the things that I think that's happened is, judges don't know what to do right now. So they're diving to the gag orders as the answer. And when they dive to the gag orders and people cannot speak openly, we've got, going back to Delphi, it kills me that the family cannot speak up in this situation and have a voice for the girls. And that allows a lot of people who are either bad actors or aren't really thinking that through to go publicly speak about things without any counterbalance or weight. So it's not just, I think, the negative impact of gag orders. It's not just the prosecutors and the defense attorney, but it's also all of the witnesses in the case. So we're taking out the voices who know what's going on. The defense attorneys who have gotten the discovery, the prosecutors and investigators can't talk. And now the families can't talk. So what's going to happen in that vacuum? Rumor, speculation, sensationalism. We've got to do something to fix that problem, I think.
Yeah, and I'll just say I'm still a believer that the solution to bad speech is more speech. The solution to people saying things that are abhorrent is more people saying things, not trying to stop those people from talking. I think gag orders had their time. That time has passed. Now I think they are a net negative. And I think you've pointed out exactly how they are. The gag order in Delphi does not stop the defense from getting its point of view out. It just doesn't. And we've seen that. It may limit the prosecution a little bit just because they have more ethical obligations under the ethical rules that bind lawyers, I think, than your average defense attorney. But where it is really pernicious is what you have put your finger on. The fact that the family can't even say, please stop using the hashtag with our girl's name in it publicly. They can't even say that. They have to sit there silently while other people do it and justify it for whatever reason. And they can't say, no, we don't agree with you on that. We would like you to stop. That to me is atrocious. I think that gag order in particular is vastly overbroad. I'm surprised no one challenged it. I wish they had. And I would personally like to see gag orders go away because I don't think they have much value at all at this point, and they do a lot of harm.
Yeah, I guess that was one of the problems when I did talk to my friend, and she had said, why didn't Baldwin and them just challenge the gag order itself? I guess they went with a different direction at the contempt hearing.
These guys? are smart. I'm going to give them credit for this. They know how to turn a motion into a press release. Like if you look at a number of their motions, they're really press releases meant to influence the public. And you saw when they put out their 150-page Odinist Frank's memo, which had like what 20 pages, Brett, on actually the topic at hand. Public opinion went woo in the opposite direction. So
yeah.
These guys are media savvy. So all credit to them for that. I don't know whether it's the best or most ethical approach. I do know it's not necessarily that, but there are ways, and these guys have taken advantage of what I think, the justice system isn't really prepared for yet.
Let me ask you this, Jason. There was a time where the media, the press itself would have challenged the gag order. And I wonder if sort of the weakening of local press, even regional press, has led to a time where they either are unable to do that, not financially able to do it, or just not interested in doing it. And so if it's not the New York Times, the Washington Post, the Wall Street Journal, if it's not one of them, I was going to say the LA Times. I think the LA Times has been gutted now too. If it's not one of them interested in challenging it, is there even anyone representing the press that's in a position to say, hey, we think this violates the First Amendment?
It's funny you bring that up because I was having a conversation with someone at a news organization in Indiana last week about this exact thing. Why haven't you challenged some of these things? And they just said financially, even though, this used to be a big and powerful newspaper, we can't afford the lawyers, we can't afford the reporters to cover it. So it's a lot more difficult. And one of the things that I've noticed is that in these big cases where the gag orders do get challenged by the press, all of a sudden there are cases that the New York Times is covering or CNN is covering, and they can come in as large institutions with their First Amendment lawyers who they're paying $500, $600, $700 an hour to fight. But local community news, we have all these news deserts across the country. And, when I was growing up in the business, you could go to every major city and you could find what I would say is a respectable daily newspaper that as an institution could fight for these things. And now you have underfunded press associations. And so unless CNN, USA Today, the New York Times gets involved, it's really hard to challenge these gag orders. And frankly, it's hard to hold people to account when you're just the local community newspaper with limited resources.
No, I guess I wanted to get back to something since I didn't want to interrupt. I also see what we did with I think Baldwin and Rossi in their 150-page document was trying to try the case in the media. I think that's what they were trying. They pretty much put their cards on the table and said, here's our defense of what's going on. I think they went, I think we could all agree that they should never have gone that people who were out in white robes in the middle of the forest. I think one of their later filings was a better one when it was only 7 pages. But I think this was their attempt.
I think you overestimate people's deep desire for a good story, right? People love mysteries. They love conspiracies. And, the defense could have gone with something that's more believable, right? Like, who's going to believe the Odinists went out and did a ritual sacrifice? Probably not a lot of people, but it makes a good story. And it gets people talking about it a lot better than, I think it's 2 guys or 3 guys that are not my client. Like, people are not going to talk about it. I think it was very intentional. If that makes sense.
And let me just say this, and I hate to just, Mike, you bring up such interesting things, so we just want to jump in. So hopefully we're not cutting you off. But,
no, go right ahead.
I think one of the things we're going to have to think about is the way we treat the defense and defense strategies in cases. Because I think we, as a society, because, we believe in the whole notion that better 10 guilty men go free. Inflation, I think, is now made at 100. I keep saying 100 guilty men go free than 1 innocent man go to prison. We're willing to give a lot to the defense. I always like to point out that is not aspirational. We don't want 10 guilty men to go free or 100 guilty men to go free. It's just we like having a system that values due process such that may happen. But we want guilty people to go to prison. But if, let's say take the Delphi case, for instance. Let's say if there was no press coverage whatsoever and none of the Franks motion, and Richard Allen received an absolutely fair trial with 12 impartial jurors, and where the evidence was presented, the defense had full resources to call every expert they wanted to call, and he is going to be found guilty beyond a reasonable doubt. Like, that is one world, right? I'm not saying he will be, but let's just imagine that that is the world where if that happens, if he has a fully fair and free trial, he will be found guilty. But if the defense can taint the jury and manipulate the public and use the press to its advantage, he will be acquitted. Is that justice? And is that what we want the role of the defense to be in our justice system? Typically, because the defense has only the interest of their client at stake, we sort of just give carte blanche to the defense to do whatever. You do whatever you need to do to acquit your guy. That's your role. But what that's become is the defense doing things that are not taking place in court, are not taking place in a trial, are not with the purpose of having an impartial jury, but in fact tainting the jury. Is that a good thing or is it not? I don't think that's an easy question, and I don't think there's an easy solution to how to handle that. But the more what we are seeing now is only going to get worse as we move forward.
Yep.
But one of the things that maybe the argument, a counter argument to that, and me being a non-lawyer, because like in the courtroom, you have a very structured approach, and the things have to follow I guess it's really hard for the non-law people to see these trials and say, why you can't just introduce whatever. And one of the benefits, I think, good or bad, from Serial, for example, was that she was able to present a case where there was no challenges, where you would never have that case in a courtroom, because there's rules of how you can talk or question people, what evidence you can bring in, and what evidence has to be left out. So I think maybe one of the counter arguments is that this gives you a chance to like kind of bring things that aren't allowed in a courtroom. As I understand, the Saudi defense, so to me, some other dude did it, are really hard defenses to bring into a courtroom, because you can't you get into the probative versus, I just blanked on it. So you can't just bring some person off prejudicial. I'm sorry. So like you can't really. So like when you're trying to say bring in this third guy that you think may have did it, you can't really just bring them into the courtroom and question them, because the judge is going to be like, why the hell are you going down left field? Why are you talking about Odinism in a case on Richard Allen? So I think it gives the defense and some people a new avenue to challenge the narrative that the state is bringing. So that's one thing I could see.
It does, but that's the question. Like if you have a system that you've developed over hundreds of years with lots of rules about evidence, and it's structured in a certain way to make the balance, the lady out front holding the scales, equal between the desire to find justice and the rights of the defense, and you've done all this and you've built this system and you've got that, and that's how you believe as a society you're going to both reach justice and protect the rights of the defendant. If you have that, then if the only way you can win as a defense attorney is to go out of that system and do a whole bunch of stuff that you could never do in court, in the hopes that doing that will influence what happens in court, is that something that we want to encourage and allow? And if it is, why do we have all these rules in court? Why not just sort of have open season? Like if we've decided that that's a better way to do it because it gives the defendant more rights, and we decided we want to err on that side, well, we should do that in court. If we're not going to do it in court, then I think it is a problem if what is happening outside of court is so corrupting what happens inside that you can't actually get justice.
And that's one of the things, sort of the pre this era, when we would report on cases where there were conviction and issues would come up, we would talk about the things that weren't introduced at trial, and we'd also talk about why, because that gave people a lens to weigh the different aspects too. So I understand the point, right? Like there's a difference between what can come. We have I think a wonderful judicial system. It is not perfect. It has lots of trade-offs. It's trying to balance a lot of things. So is it always going to hit the truth? It may not always hit the truth, but it's really driven to be fair, right? And that's a different question than the one the media is asking when they're covering things and when they're trying to cover it. So I think it's really important for us to be nuanced about when we're writing about it, why this came in or why this didn't come in, and what the underlying reasons are. But I think Brett makes a really, 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 really good point. I hate to go back to the hashtag, but justice for Abby and Libby, and fairness for the defendant are two very different things. The argument that people make is that you're not, the defendant's name, Richard Allen in that case, that you're not going to have justice for Abby and Libby without justice for Richard Allen. Now, you need a fair trial for Richard Allen because that's what our system demands. You need justice for Abby and Libby. That's also what our system demands. And there's a balancing act. Richard Allen could have an absolute fair trial. He could have killed the girls and he could still get acquitted. That would not be justice for Abby and Libby. So those are very different things. Yeah. I think people need to differentiate between them. And I think they need to advocate for both, but recognize they are not the same thing.
Correct. But that also applies to a lot of the cases we hear too. Like, don't want to go with the main one. They always, justice for the victim, but the main guy that did it, that strangled her, that if he gets out of jail, there's no more justice for him. So, that's every single case. And I guess that's maybe what makes it interesting or frustrating at the same time when we deal with true crime, because I guess, the internet and your own channels or whatever gives you everybody an opportunity where before I don't think you would have ever I guess we don't know everything about Brian Kohlberger, but that one seems pretty open and shut if everything we've had is true. So I guess we kind of wait for the trial on that one. But
I think it's equally important to fight for both, right? Recognizing there may be times where there conflict, like Brett was saying, the inflation-oriented 100. We'd rather have 100 guilty men go free than one innocent man go to prison. That is representative of that conflict, right? We're looking for both fairness and justice, recognizing that they will not always line up, but most or a lot of the time they will. And so it's really that balancing act. And I think one thing that's changed recently, taking those recent cases, a lot more focus is on fairness for the defendant. And some of the, in my mind, talk about justice for the victims is platitudes, right? People are using it as props. They are using it to virtue signal and make themselves look good, but they're not really focusing on the things that would bring justice to the victims. And so, yeah, I just think we're moving further from a just system if we're thinking about it that way and we're just paying platitudes to those things.
And I think, defense attorneys don't care about justice for, I'm not going to say they don't care. They may personally care, but they don't, their professional, legal, and ethical obligation is not to the victim. It is to their client. And that's fine. And it is great and wonderful that is their obligation. And we love that. And we want them to be passionate about defending their client. But defend your client. I feel like there has been, as you were saying, this, we're going to co-opt sort of some of the victim side too to help defend our client, because it's helpful for us to defend our client. And once again, I get it. That's your job. But it seems to me, it always strikes me as disingenuous, because I think most people who are on the defense side, their job is to get their client acquitted, whether he's guilty or not. And then they move on, right? Like, I don't think your average defense attorney, I don't think that Rosie and Baldwin, if they get Richard Allen acquitted, will then spend the rest of their lives trying to find who truly killed Abby and Libby. And that's not their job. And that's fine.
Yeah. Yeah. I guess the person or who defended Casey Anthony, you're right, is not trying to find out who killed Casey Anthony, or OJ, and nobody's looking for Nicole Brown and Ron Coleman's killers right now. So, yeah. So that is, I guess that's I kind of brought it out. Like, I understand it when it's your client that you have to defend them, but I guess there some of these we're getting into where they're defending other people's clients more, like as strong as they are to defend clients, and that's maybe one of the problems I can have. I don't know. So,
well, and you have to look at it, right? Like the defense attorneys, and I don't want defense attorney bash, but they love to wrap themselves in the Constitution, Sixth Amendment, fairness. But to Brett's point, their job is to get their client off. And that can be sometimes by hook or crook. Like, could you imagine a world where your defense attorneys are like, you know what, man, you're getting a fair trial. There are a couple other things that I could do, but you know what? We got to the fair trial standard. I'm not going to manipulate. So, like, there's a real big difference between what defense attorneys sell their job as and what it really is. It's to get their client off. Yeah.
If violating the Constitution or not honoring the Constitution will get your client off, that's what you're supposed to do. You know, when you file a Fifth or Sixth Amendment challenge to evidence that you know isn't really supported by the Constitution and the case law, you don't say, well, you know, as I read the Constitution, that was a perfectly legal search, so I'm not going to challenge it, even though, you know, maybe I could convince the judge to change the law or to ignore this precedent that's against me. No, you file it, you know, and it is true that the defense attorneys often find themselves in the position of defending various constitutional rights that apply to defendants, but that is a happy coincidence because it is useful for them in the defense of their client. And, you know, prosecutors defend the Constitution too. When I oppose one of those Fifth or Sixth Amendment challenges that aren't actually in keeping with the Fifth or Sixth Amendment and I win, the Constitution didn't lose. The Constitution was upheld. So I just think it's important to remember that when you're out in the public, because there's a lot of propaganda now out there that is meant to influence the way you look at evidence and the way you look at arguments. And a lot of times defense attorneys believe that the best thing they can do for their clients is to undermine people's faith in the justice system, undermine people's faith in the judge, undermine people's faith in the police. And that is an avenue for them to advocate for their client. We can argue whether or not they should do that, but I think it is important to understand that's what they're doing. They are not out there fighting for you.
okay, I think that's a mic drop. No, okay, I guess I'm not quite sure where to go after that one. So, sorry.
No worries. You would, you know, at the top of it, you had mentioned that you wanted to talk about some of the balancing of the sixth and the first. Would it help to just sort of like speak to, like, I can give you from my journalist perspective, you know, we certainly as journalists wrap ourselves in the Constitution, probably better than anybody else. But, you know, I think that, you know, for us, I think it's super important that we are conscious of all these rights, that we are conscious of and paying attention to justice, but as creators that we really are being responsible, minimizing that harm, respecting the judicial system when it's working, and calling it out when it's not. And I think one of the questions, the unanswered questions for us as a community of creators or journalists is how do we create a system where all of those listeners, all those people who are in the chat right now, know what is reliable news, and they are able to get news where government is held to account and where they do get truth. And we haven't solved that problem yet. And I think that's going to be one of our, from the creation and journalism perspective, that's going to be one of our big challenges. And I'm not as versed in the judicial system, but I think Brett hit on a really great point that, you know, I think prosecutors, judges, the system that moves slow needs to think very quickly about how it's going to adapt to the new reality that it's in.
Okay, well, I think that might actually be a good stopping point for tonight. I guess maybe I'd like to, I don't know if, is there other systems around the world where it's a little bit different that compared to the antagonistic system that we have? I don't know if that would be a good discussion question later or not, but.
Yeah, like Russia, where they're not antagonistic at all. North Korea.
Okay, we win. We win on that one.
There's the French system, which is inquisitorial.
Yeah.
So it's very different. It's weird. It's like you don't have a right to not speak. it's I don't know. It always looks like chaos to me, but I guess it works.
Italy, yeah. That watching that Knox trial, I was like, what is happening here?
Yeah, I mean, I guess talk about something that's bad for the defense. I mean, don't want to like you could. I mean, she got around the double jeopardy protect like find them guilty or innocent, and then oh no, we screwed up. We're gonna try you again. So
But
I guess they don't have the same double jeopardy protections.
A system when you're looking at the law and media that's a little different, but it's also free that is worth looking at is Canada, where you basically can't cover investigations because they'll release nothing during the investigation. And England is another example where they will black out. They'll put media blackouts because they have less press freedoms during trials, so you can't get information. And if people want examples of sort of like more free press where they have more restrictions, I'd look to those. And I think most Americans would tell you that despite all the bad things that we have to deal with, they probably want a system to ours. Brett had to go. Yeah. It's a wrap.
Yep. Well, thank you for taking the time to talk with me today. It seemed like we had a good conversation, and people enjoyed it in the gallery here. So, you want to stop recording? I'll hang out for a minute or two.
Yeah, we can. You know what? I can just cut this out of the video when I send it over to you. Do you want to, Mike? Do you want to say goodbye to all the people? People, thank you for showing up.
Yep, thank you.
I love seeing those names. All right. See you guys. Have a great night.
Goodbye.
All right. And this will be up on Mike's channel.
Yeah,